recognition.
Thank you, Mr. Chairman. So we have a special recognition today for former Commissioner Bob Watts.
Correct on that. With that great legal analysis that we did, we lost the vote. But Bob, again, I appreciate everything that you did on the commission. I'm certainly glad that I've gotten to know you. Again, I consider you a friend of mine now, and I hope we stay in touch.
So I remember that meeting a little differently, and not at all for the legal reasons, but it was a special call meeting to deal with. It was during suspended session right after COVID hit, and they were still in the legislature, but they suspended, and there was the prohibition of raising money, and it was truly telephonic. Virtual wasn't even a thing really. But what I remember is, because at the time we hadn't really figured out Zoom and all that, anyone who wanted to be involved just called in. And at some point you heard a toilet flush in the background, and I could feel the steam coming off of Bob's head during that meeting. So that's my recollection of that meeting. But the legal analysis, I'm sure, was great as well.
We've never run into that in here.
Are there any other commissioners that wish to make any type of comment or anything, at this point? Okay. Do you want to come?
Sure.
And receive your plaque?
Thank you very much, guys.
Come on down here if you would.
I think that's what it
Mr. Watts.
So you want me to come over here?
is. Definitely think that's what it is.
Thank you.
Okay, great.
Thank you, guys. I appreciate it. All right. Well, yeah, good luck. Yeah, I'm gonna leave just before the executive.
Yeah, right.
Thank you.
All right, I think that takes care of item 2 on the agenda for the special recognition. We're going to move on to item 3 on the agenda. Because Mr. Watts is no longer serving us, he was the vice chair at the time, we do have a vacancy with regard to the position of vice chair. What I will say about that at this point is that historically, the process has been anyway that the person with most seniority on the commission has been chair, and that the person with the second amount of seniority has been vice chair. And with that in mind, and I'm certainly not saying that we're confined to that, in any way, but what I will say at this point in time is that, I believe that Rick Thompson is the one that's got the next amount of seniority, first of all. And I would also comment that, Rick is very familiar, Commissioner Thompson is very, very familiar with the workings of the commission. He's actually served as executive director, executive secretary of the commission, and he's probably got the most working knowledge of any commissioner up here with respect to the Campaign Finance Act. So with that being said, I'm going to go ahead and make a motion that we elect Rick Thompson as our new vice chair. I got a motion and a second. Is there any discussion? Hearing none, I will call the question. All in favor say aye. Aye. Any opposed? All right, that motion carries. Congratulations.
Thank you. There are people that are probably joining, and when they find out, are going to shudder.
Is that your only comment at this time? Okay. We'll move on to item 4 on the agenda, which is the review and approval of the meeting minutes for our last meeting, which was held on March 27th, March 27th, 2023. Have all the commissioners, again, with the exception of our new Commissioner Wise, had an opportunity to review the minutes of that last meeting? I'm assuming that they have. Are there any questions or comments, changes, concerns, anything of that nature which anyone believes need to be made to the minutes of the last meeting? Hearing none, I'll go ahead and make a motion to approve the minutes of the March 27, 2023 meeting as presented.
Second.
We got a motion and a second. Is there any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye.
Aye.
Any opposed? Any abstentions?
Aye.
Thank you. That carries, and we'll go ahead and have those approved. We're going to go ahead and move to item 5 on the agenda. Items B and C, again, will be continued from today's meeting, and we will go ahead and call the case 22-0005-C in the matter of Janice Laws Robinson. Looks like Mr. Cusack has got that case. Welcome this morning, Mr. Cusack. Hold on a second. Where are we? I thought that was his chair. That's his chair.
What's the,
We got it. I should know that by now.
Commissioners, this is in the matter of Janice Laws Robinson. This is case 22-0005-C. This was a third-party complaint which was filed on February 9th of 2022 by Luke Moses. There was a couple of allegations made in the complaint, numerous allegations. The commission's only moving forward on one of those allegations, but the initial complaint alleged that Ms. Laws Robinson violated the contribution limits, failed to file campaign contribution disclosure reports as required by OCGA 21534, and then failed to file a 2-day business report. We are only moving forward on the failure to file the campaign contribution disclosure reports. The contribution limit allegation was actually a husband and a wife, so they can make those contributions separately.
Sorry, Mr. Cusack. Are we okay on the video and everything?
Yeah, sir, I'll just need this for y'all to be able to see it.
Okay, let's wait 1 second. Tell you what, before we do that, I just want to go through this, with regard to the notice issues,
Yes.
just real briefly. So as I understand it, there were complaints filed on February the 9th of 22. Is that right?
Correct.
All right.
And then there was another complaint that was filed separately that's in the administrative dismissal portion of today's agenda.
Okay. But with respect to this particular complaint,
Yes.
I saw 2 notices that were sent on February the 9th of 22, and then the second one was sent on February 16th of 2022. Do you know what, can you tell us what the reason was for the 2 different notices being sent out?
I believe we found an additional address and we sent it to her law office, in which we received a response, a formal response to the complaint from her.
Okay. And then this notice of preliminary hearing it looks like it was sent on May the 18th, is that right?
Yes.
And service was accomplished with respect to that as well?
Yes.
And I thought that I saw in there that it was that refused by the recipient?
I think they can choose not to sign for it. I guess they get served with it and say, I don't want to sign for it.
Okay. And then it looks like there was another one that was actually sent on May the 22nd. That one was actually marked, or do you know, was that one marked received?
Yes, and that was received.
I got you. Okay. And then there's a response that I see in the packet as well. It looks like she sent in a response on March 31st of 22.
Yes,
Okay, so that would indicate that notice was accomplished and everything was served in that regard, right?
correct.
All right.
And that was where we're talking about the contribution limits. We were able to determine it was a husband and wife contribution there.
Okay. By the way, it looked like this was actually very timely with regard to the commission's work on this, because I've got down that the complaints were filed on February the 9th, and that the first notice was actually sent on February the 9th as well. So
Very quick.
the efficiency of that
That's right.
is speaking well for the actions of the commission staff. Okay, are we good on the technology?
screen was just for us though, screen for the viewing audiences.
Yeah, and if it only takes them a minute to get it done, then, we'll go ahead and just start going through, because again, are you gonna be showing anything that's outside what's in the packet?
I don't think so. There may be some, I don't know if y'all have the campaign contribution disclosure reports, but I can easily describe them as well. Okay, yeah, then it should be fairly easy then.
Well, why don't we just go ahead and proceed then, and
Okay.
we can continue to work on the technology if necessary.
PowerPoint's actually available on your laptop as well.
Okay.
You can click on PowerPoint down there. It should open up as well.
And I think we don't have what we typically have, which is the link, because I was told that the Adobe, system, for lack of a better term, has gone down, and we are on Adobe's work list at this point. So we'll have to scroll all the way down.
Okay, yes. I couldn't get the search last night,
Sure.
but I can't see it now.
Okay, good. So that's the procedural history. We're only moving forward on the allegations of the failure to file the campaign contribution disclosure reports. Just a little bit of background on the case. Ms. Laws Robinson was a candidate for insurance commissioner in 2018 and 2022. She won the Democratic primary in both elections and was unsuccessful in both general elections. She finished her campaign in 2018 with approximately $3,000 in unspent contributions, and that's what this complaint centers on. What we're going forward on is actually the 2018 end of the campaign up until the beginning of the 2022 election. A candidate who is unsuccessful and still has leftover contributions is required to file a campaign contribution disclosure report once a year by December 31st of that year when they have contributions or cash on hand. As opposed to a candidate who is successful or who leaves office and resigns, they would file twice a year. A candidate who is unsuccessful files once a year, and that's just one report by December 31st, meets their statutory requirements. This case is a little unique in that what the campaign did was actually file campaign contribution disclosure reports that were just zeros. So what that means is they just filed something that showed nothing happened with the campaign. And commission precedent and what we have determined that to mean is that you're actually, when you have cash on hand and you're doing this, what's called a zero report, those are not filed reports. They do not count because nothing in them is correct. You're statutorily required to swear that what you're affirming here is true and correct, and we've determined that this is just in no way correct, it's no way meeting your requirements, and it's ultimately misleading the public. So there was, and I can get in and I can show you what I mean by that, but in this case, they're just zero reports. They just click a button saying no activity, and then that's that. It's not accurate in any way, shape, or form.
Why do we have that? Why do we have that button if somebody's going to push it and you're not going to say it's filed? I don't know. So how can we say it's not filed? We can say it's inaccurate. How can we say it's not filed?
So that's something we've always interpreted it to mean. Let me give you an example. It could be true in that we have this button where a campaign doesn't have any activity, and you file zeros. Say a campaign is just starting out, you file a declaration of intent to run for office on June 29th, and you have a report due on June 30th. You don't have any activity, you click that button, that's zeros. But when you're actually swearing and affirming that the information is true and correct on these filings, and we can tell it's incorrect, then we have determined that to mean you're not meeting your statutory obligation and that this is ultimately not filed. So that's what we have determined as commission staff and commission precedent in prior cases. We have determined those filed quote-unquote reports are actually unfiled.
Commissioner Hicks?
You have to file a report if it's all zeros?
Yes, you
still
do. Yes, you still do. And there's some exceptions to that, but we have the option of, so say a campaign terminates December 31st, and what I can tell you and how this case should have progressed or how it should have been filed is October 25th shows a roughly $3,000 in cash on hand. December 31st, to terminate your campaign, you would have to show where that $3,000 went. And then you have a zeroed out cash on hand, which counts as a termination. So that was never done, so the filing obligations continue. So if you get to zero and you can terminate your campaign, that counts as a termination. Your filing obligations, you don't have anymore. But that was not the case in this present case.
And just to clarify, what Mr. Cusack is saying is true of a state level campaign. But at the local level, there is an affidavit of exemption that local candidates can file. It's not an option for state candidates, where if they swear and affirm they're not going to take more than X number amount of dollars, then they waive certain filing obligations.
So here's the law stated in OCGA 21534. It's the election year reporting schedule. For each election year, a candidate who is running in that year has to file a January 31st, April 30th, June 30th, September 30th, October 25th, and December 31st campaign contribution disclosure report. Those are required. Now, on December 31st, you could, if you get your balance down to zero, to no cash on hand, then you can terminate your campaign, say if you are an unsuccessful candidate. Here's what I was talking about with OCGA 21534I2, and this is for unsuccessful candidates and what's required of them, in that they have to file a supplemental campaign contribution disclosure report no later than December 31st of each year to meet their statutory requirements if they still have cash on hand left over. And I'm showing right here is the October 25th, 2018 election year report. There is $3,396.87 left on hand here. So that money should have been accounted for on the next report, on the December 31st report to finish the election cycle. And if we go forward to the December 31st, 2018 election year report, you just see zeros there. The cash on hand should have shown however much had been in that election cycle. All that money should have been brought forth to account for what the total amount of activity the campaign had. And here, you just go in the system, you click a zero button, and that's that. So it's in no way meeting what is required. So that's the December 31st, 2018 report, which shows no activity. The next one is the 2019 supplemental report. That's the same, it shows the same thing with zero activity. So we still don't know where this final cash on hand, or if there were any contributions made to the campaign from the period of October 25th until Election Day, which I don't have the records in this, so it's fair to assume, just based on campaigns I've seen for statewide office, that there would more than likely be contributions and expenditures from that last report up until Election Day for a statewide candidate. So we are missing that data from this campaign.
I want to go back to that other violation real quick that the staff is recommending. So I thought that I heard you say that the first, that number one, I guess, under this particular complaint, that violated 34I2. And again, I'm just looking at the summary that's been set forth here. If I heard you wrong, just let me know. The first one's actually a 34C2A, right?
Correct. That's the only one. The rest are going to be I2.
Okay. Go ahead, sorry.
So this is, I already showed the 2019 supplemental report. The 2020 supplemental report is the same thing, where it's showing zero activity. Again, we know this is incorrect because we still don't know the disposition of that $3,300. And then in 2021, there was never a report filed. So when she ran for office in 2022 again, filed the January 31st report, we actually still don't know, there's no accounting for that $3,300. So she was actually required to file a 2021 report that would have disclosed that. And then the campaign started again anew in 2022. And they just started with a blank, basically a blank slate. So we still don't have an accounting from that final number, or if there were any contributions and expenditures from October 25th up until Election Day and even after that, which normally a statewide campaign would have some expenditures due or some outstanding invoices for what was done to that December 31st period. That's pretty typical of what we see from a statewide candidate there. So we just don't have a proper accounting for that time period as well.
So you know your PowerPoint's up.
Okay. So this is the 2020 supplemental report, shows zero balance, and then 2021 wasn't filed as well. So that was just not filed, and so we are saying that there's 4 violations in that the December 31st, 2018 campaign contribution report was failed to file, and that's 21534C2A because it's an election year filing. And the rest for 2019, 2020, and 2021 would be a violation of OCGA 21534I2. So we would ask you find probable cause to move this case forward to the Office of State Administrative Hearings.
Before I give everyone else an opportunity to ask any questions, raise any concerns, anything of that nature, I've got a copy of this March 31st, 2022 response that was filed on behalf of Ms. Robinson. Will you address each of these arguments? It looks like there are 3 separate arguments.
Yes.
I've got a copy right here if you want me to give it to you. I guess to some extent they may not be arguments as much as requesting time to do certain things.
Yes, so the initial argument, I would say, goes against what commission staff and commission precedent has been. They are trying to say they complied with the statute even though they have filed 0 reports.
And just for everyone's benefit, give a summary of that first argument and then your response to that.
Yes, so their response was after an unsuccessful election, she was required to file her campaign reports until the report is zeroed out and terminated. So they're acknowledging what they have to do, which as an aside, wasn't done in this case. She continued to file based on supplemental filing requirements that only require 1 filing per year, to which the campaign says she did complete in 2019 and 2020. I would point out still, that is a correct interpretation, that you are supposed to file, like I said, once a year. However, the information needs to be correct, and obviously it's not correct. She further goes on in 2021, Ms. Laws Robinson says she contacted state ethics to determine if she needed to terminate her first report to open a new campaign, and was instructed to file in the new ethics system but continue to report using the same filing ID as she did with her supplemental reporting. And they're claiming she has not committed an offense of missing reports based on the status of her campaign at these different times. She would have had to continue to file in 2021, and she ultimately did use the same filing ID for 2022. So these reports would have been in there, the 2021 would have been there for her to file, and it wasn't in this case. But also the information isn't correct. So we would determine those as not being filed. The other responses, Mr. Chairman, I don't know if you want me to go forward on, ultimately we agree with everyone. We didn't move forward on those, so that the 2-day business reports, I looked into that, the report didn't generate for her, so we didn't move forward on that allegation. And then the missing contributions, there was nothing to amend on their end from their check. So I don't believe there was anything for us to move forward on. There was nothing to prove that there were missing contributions, so we didn't move forward on that allegation per their request, but also based on what they submitted. So there was nothing evidentiary-wise for us to move forward on that allegation for, which is why it's dropped off and we're just moving forward on these reporting violations.
Okay. Again, I think it was important to go over that since that was the only thing I saw in the packet in terms of a response. Has there been any communication with her or on with anyone else on her behalf since she sent in that March 22 response?
There were a couple emails earlier this year, but since then it's been radio silent. And I think after the election in 2022, it's just been sort of silent from their end.
Any comments, questions by any commissioners? Commissioner Thompson.
So going back to my point earlier, you said that if you determine the report is inaccurate, then you're going to classify it as unfiled.
And let me go back. And inaccurate in that, sure, campaigns can have accounting issues or miss a contribution here and there, or miss an expenditure. That's not what I mean by inaccurate. What I mean by inaccurate is having cash on hand and then filing a 0 report.
is there not a better statute we can say that she's violating and saying it's an unfiled report? I don't like the idea that any agency would just determine something even though it was filed through our system. I understand it's inaccurate, but I don't. Pick another section, one that she didn't report her expenditures or contributions or, missing information. I just don't think unfiled reports, we should determine a filed report is unfiled.
I'm not trying to hijack the mic from Mr. Cusack. The problem, I understand your point, Mr. Chairman, or Mr. Vice Chairman. The problem with that is when they ignore subpoenas and we don't know where they bank, how can we determine what are the missing transactions when we can't access it?
Sure you can. Yeah. 100% you can. You can show that there was $3,300 and then her next report is 0 and there's no expenditures there. You can determine that 100%. That they violated the law by not reporting the required expenditures.
How do we know they had an expenditure during that period?
Okay. You can't know. I think you can show that because they swear in a test that they have no money left. So they had to have an expenditure. I just don't know how we just say, okay, we're not going to accept that it was filed, even though you filed it, and you have a timestamp.
So I think in this case, we have determined this for 0 reports, for reports filed with no activity. For a candidate who files a report and there's missing contributions, missing expenditures they find after doing an audit, something like that, and they go back and amend. That's not this. That's something we encourage to go back and amend those. Here we have somebody who did the bare minimum to get this filed. They clicked a button, they logged in, they clicked a button, knew it was wrong, and filed it. That's different than I think what you're getting at in terms of mistakes being made. I mean, this is a willful effort to just not comply with law or the rules. And we have considered that to be not filed in the past. I mean, there's precedent on that in which we have had cases where we've determined that these are not considered filed. So that's why we're moving forward on this, and we don't move forward on something like that as mistakes made or contributions or expenditures added, as even though they're mistakes, we said that that's filed, and you can continue to amend reports based on that if you'd like.
So is there another statute that would potentially apply here based on the filing that was accomplished?
I mean, we could refer it for misdemeanor prosecution under the powers of the act, but that's not something we've done in the past. But given the information we have and the lack of a response to a subpoena, this is what we would move forward on. Because I disagree with we know there's an expenditure made. There could not have been. That $3,300 could still be sitting in a bank account somewhere. And there's just what they didn't do was carry over the correct balance. So that's why I would be afraid to go forward on saying that expenditures were made without proof of actually it coming out of the bank account.
Well, I don't think that the system is really that easy to file a no expenditure report, because just logging into the system sometimes.
Well, we're talking about 2 different systems.
Okay, just say it.
No.
I'm just saying.
The old system, you can just click that button.
Okay.
That's not the case anymore, for good reason.
But I go back to, I don't know how a judge, and I don't have a law degree, I don't know how a judge would say, okay, we can move forward with this statute of an unfiled report, even if they present one where it has a timestamp on it that says filed, which our system allowed them to do. So I just don't agree with this statute as being the appropriate one.
I mean, it seems to me that arguably there could be, a violation of both, right?
Yes.
And the commission just chose to proceed under one.
Yes.
Okay.
It's fact specific, but it's possible, yeah.
Yes.
Okay. All right. Commissioner Bird?
I don't want to jump into this. I get the point. I think our alternative is to allege a fraudulent filing under whatever appropriate statute. And I hear you that we're not there yet. That may be the case. And to me, that sounds like a more onerous prosecution than what we're proceeding with.
Correct.
But that's my, we've jumped around on what the violations are, but I just wanted to clarify in my mind, what we're missing basically two things. We don't know what happened from October 30, well, from November 1 to Election Day. We don't know what came in and what was spent. So that's the one missing piece.
Yes.
And then we don't know what happened to that money, which she only had three, assuming there was money left, there's only three things she could have done with it legally: give it to another candidate, give it to a charity, or give it back. And we don't know. So those are, I mean, to distill this down, those are the two missing points that I hear. Is that correct?
That's correct.
And we don't know from November 1 to whatever date Election Day was, November, and
And after, we
you
don't,
know, whatever was in the mail, and
yes.
we don't have anything on
Yeah,
that.
we have no idea.
Okay.
Will you give Katie my notes? Thank you. Do we have any further discussion or questions for Mr. Kuzinek on this one? All right, hearing none, I'm going to go ahead and make a motion. I move to find the reasonable grounds to believe that a violation of the Campaign Finance Act was violated for the December 31, 2018 election year CCDR in violation of OCGA 21-5-34C2A.
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? So we'll make a record of Mr. Vice Chair's no vote on that one. Motion nevertheless carries. With respect to the other allegation, I'm going to make a motion to find reasonable grounds that the Campaign Finance Act was violated by a failure to file a 2019, 2020, and 2021 CCDR in violation of OCGA 21-5-34I2. Do I have a second?
Second.
Got a motion and a second. Any discussion? Mr. Vice Chair?
Is it not sure there's actually one report that was never filed?
Correct.
Can you separate that one out?
2021.
The 2021, can you drop that one off your motion?
Yeah, would you want to, I guess, motion to amend the question there and then I'll address the one after?
Sure, so moved.
Do we have a second?
Second.
We got a motion and a second with respect to the amended question, which removes the violation for 2021. We'll go ahead and call it. Well, is there any further discussion on that? I'll go ahead and call that question. All in favor say aye. Aye. Any opposed?
Because now you got to do 2020, he's going to agree with you on
Okay.
that. Oh, yeah, I'm sorry.
So that's a unanimous vote, which separates out the 2021 as not being included. All right. And so I'm, with the one question that remains, I am going to go ahead and find the reasonable ground. Excuse me, I'm going to move that we find that reasonable grounds exist that the Campaign Finance Act was violated with respect to the 2021 CCDR in violation of OCGA 21-5-34A2. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing no discussion, I'll go ahead and call the question. All in favor say aye.
Aye.
Aye. Any opposed? Hearing none, the motion carries.
Do we need
We didn't vote.
We need to vote on the.
Because the only thing that we did on that one was actually just amend my motion.
Yeah.
You gotta vote on the substantive.
No, you guys are right.
I'm
Yeah.
losing my mind.
Yeah.
So you-
But we did go ahead and address the 2021.
You're correct.
I know.
I think we still got a motion on the floor. You took-
Oh, with respect to the first one.
With 2019 and 2020 supplemental reports is still on the floor.
That's right. And I apologize.
Yes, sir.
So with that motion on the floor, is there any discussion? Well, I guess we need to ask for a second on that.
Now, you have the second because it was amended. So you amended your motion.
You're right.
and You had the second.
You're right. Thank you. See, you cause too much.
It's fine, we'll do that with Vice Chair.
Yeah. All right, with respect to that amended motion, there is a motion and a second. Any further discussion on that amended motion? All right, hearing none, I'll go ahead and call the vote on that. All in favor say aye. Aye. Any opposed? Aye. All right, so we got it right now. And again, I apologize for that. All right, so that takes care of all the preliminary hearings, right? All right, we've got a host of consent orders. It looks like we've got A through Y. And before we get into that,
Which rule?
we're gonna address that. But do we have any that aren't signed at this point?
I believe they're all signed.
Okay, I just want to make sure. And again, yes, I'm going to go ahead and address the fact that we now do these under what we have now labeled the Hicks rule, and this is for really Commissioner Wise's benefit. Commissioner Hicks, do you want to go ahead and explain how we're doing these now?
The purpose of this is that it means that everybody agrees. So really, you don't have to get into the details of it, 30-second clip to go through all of these, and then we vote on all of them at one time.
All right, Mr. Cusack.
All right, the first one is 22-0092, Lethia Cottrell. She was a candidate for State House 156 in 2020 and 2022. She failed to file a termination, or a December 31st, 2020 CCDR, has agreed to a $125 late fee and a $125 civil penalty for a total of $250. Next one is 22-0163-C, Ms. Patty Bentley. She's the current state representative for District 139. She failed to file 2 election year CCDRs and failed to file 2 PFDSs. I will say she met with the commission and she came into the office and we were able to work through her filings. She is paying a $500 civil penalty, $250 in late fees. She had already paid $250 in late fees via the campaign finance system. So 250 of those had already been taken care of for a total of a $750 fine. 23-0018-C, Mr. Marshall Orson. He was a candidate for the District 2 DeKalb Board of Commissioners and a former Board of Education member. Unsuccessful candidate, but he failed to file an October 31st campaign contribution disclosure report and had a $125 late fee for that one. They were extremely cooperative, perhaps the most proactive campaign. Within a day of the complaint being filed, they had filed the report. 21-005-C is in the matter of David Schaefer. Mr. Schaefer was the State Senate District 48 Senator for 17 years and then ran unsuccessfully for Lieutenant Governor. He left office with excess contributions and was continued to file reports twice a year until that balance was retired. He failed to file 5 supplemental campaign contribution disclosure reports and has agreed to pay $625 in late fees and a $1,250 civil penalty for a total of $1,875. 23-0016-C is in the matter of Michael Thurmond. He is the current CEO of DeKalb County. He's failed to timely file 7 campaign contribution disclosure reports in the 2021 PFDS. The campaign also took contributions in excess of the $3,000 contribution limit. So there is $1,000 in late fees and a $2,000 civil penalty for a total of a $3,000 fine.
You skipped David Chastain.
Right.
Oh, and then in the matter of David Chastain, 22-00160-C, Mr. Chastain was a Cobb County, he is a Cobb County Board of Education member. I believe he violated the contribution limits as well. The exact number that he's paying.
$250, plus he's refunding the excess.
Yes, he is. It's $250 and then refunding the excess contributions to the contributors. And I forgot to mention, Mr. Thurmond did the same thing as well. He refunded the excess contributions to the contributors and was very proactive about that. Last one is 22-0124-C, Ms. Zara Karinchak. She was the former District 48 state senator. She left office with excess contributions as well and needed to continue filing twice a year. She failed to file on December 31st, 2020 CCDR and June 30th, 2021 CCDR. So there's $250 in late fees and $125 civil penalty for a total of $375. And those, I believe, are all of my consent orders.
I think Mr. Baywell's going to be next.
Position H, Tax Relief and Comprehensive Education Reform, or TRACER, case number 20-16. TRACER was a corporate entity that existed in 2020. They were primarily a group that advocated for tax reform in Troup County. They had purchased approximately $2,500 in items on behalf of 4 candidates for Troup County Board of Education. That triggered registration and reporting requirements under the law. They've agreed to one violation of 21534F1 for failing to register as an independent committee. They've agreed to pay a penalty of $200. Position I, Robert Patrick, 23-22. He was a candidate for DeKalb County Board of Commissioners in the 2020 election cycle. He agreed on 3 violations of 21534. He failed to file in August 2020 runoff primary CCDR, and October 25th, 2020 CCDR, and the December 31st, 2022 CCDR. He agreed upon payment of $375 in late fees, $125 civil penalty, total penalty of $500. Committee for City of Mableton, 23-26. This was a registered ballot committee in the 2022 election cycle. At the conclusion of the election, they had excess funds on hand, and the law with respect to ballot committees is pretty specific. Any excess contributions you either have to donate or return to the donors pro rata. They erred and they made a donation of $1,882.96 to a candidate that was running for City of Mableton City Council. They agreed upon payment of a $500 civil penalty for the violation, and that was a violation of 21533D2. Position K, Vincent Lottie, 23-0023. He is the sitting Henry County State Court Judge. He was originally appointed back in 2020 and then won re-election in 2022. He agreed on 8 total violations. Violations 1 through 6 are 21534 C2A violations. He didn't file CCDRs for January, April, June, September, October, and December of 2022. He also, violations 7 and 8 were violations of 21550, and he failed to file calendar year 2020 and 2021 PFDSs. He agreed upon payment of $1,000 late fees, $500 civil penalty, total penalty of $1,500. Position L, Donald Broussard, 23-0005. He was an unsuccessful candidate for the DeKalb County Board of Commissioners in the 2022 election cycle. He filed a DOI and actually terminated his account or terminated his candidacy prior to the primary election. He agreed that there was one violation. He failed to file a June 30th, 2022 CCDR. That's a 21534 C2A violation. He agreed upon payment of $125 late fee, $125 civil penalty, for a total penalty of $250. Position M, Miss Emily Halvey, case 23-12. She was a candidate for DeKalb Board of Commissioners in the 2020 election cycle. She agreed on 3 violations of 21534 for failing to file her June, September, and October election year CCDRs. She agreed upon payment of $375 in late fees, $375 civil penalty, for a $750 total penalty. Position N, Catherine Gannon, 23-11. She was served on the DeKalb Board of Commissioners from 2004 through 2020. When she left office, she stopped filing CCDRs, and she did have excess contributions in her campaign account. She agreed that there were 5 violations of 21-534I1. She failed to file December 2020, June 2021, the December 2021, the June 2022, and the December 2022 CCDRs. She agreed upon payment of $625 in late fees, $375 in civil penalties, for a total penalty of $1,000. Position 8, MD Nazer, case 23-0008. He was an unsuccessful candidate for the DeKalb County Board of Commissioners in the 2020 election cycle. He agreed on 2 violations of 21-534C2A. He failed to file June and September election year CCDRs. He agreed upon payment of $250 in late fees. Position P, Jacqueline Harling, case 22-0077. She was an unsuccessful candidate for the Georgia House of Representatives in the 2022 election cycle. She agreed that she had 2 violations of the Campaign Finance Act, section 21-534C2A. She filed late her April 30th CCDR and failed to file a June 30th CCDR. She agreed upon payment of $250 in late fees. Position Q, DeJaris James, 22-113. She was the unsuccessful candidate for City of Atlanta School Board in the 2017 election cycle. She agreed that there was 1 violation of the Campaign Finance Act, a violation of 21-534C2A. She failed to file a December 31st, 2017 CCDR. She agreed upon payment of $125 late fee, $125 civil penalty, for a total penalty of $250. And that concludes my case study.
Thank you, Mr. Baywell. Mr. Knittel?
Yes, sir. Start with position R. Courtney English. Courtney English actually has 2 cases, 22-0136 and 22-0141. In the first case, 22-0136, in that case, Mr. English was he was the incumbent for Atlanta Public School Board of Education District 7. However, he did not run for re-election in 2017. He left to run for City Council position, lost that. But in this case, he had excess contributions. He had not filed a CCDR to close that account out. He has since taken care of that and completed that. So his violation of that case was failure to file December 31st, 2017 CCDR. And in that case, he agreed to a civil penalty of $375 and $125 late fee for a total of $500. In case 22-0141, in that case, Mr. English was a candidate for Atlanta City Council President in the 2021 election. He lost. Again, in this case, he had some excess contributions and did not file a December 31st, 2021 CCDR. Has since resolved that and filed those, and so that is a violation of failure to file December 31st, 2021 CCDR. Again, that's a $375 civil penalty and $125 late fee for a total of $500 on that case. The next matter, Edna Branch Jackson, case 22-0168. Ms. Jackson was a General Assembly State House District 165 candidate. She won in 2022. She had failed to file late files of CCDRs from actually several of them, January, April, June, September, and October. Ms. Jackson was one of those individuals that when she received the complaint from our office, she actually came in, physically came into our office, worked with office staff to understand how to use the system. I'll just suffice to say she didn't understand computers very well. And so that's all corrected. She was very cooperative. And the system had already automatically generated late fees for those, and she paid those before we ever got to today's date. And so her assessment, or what she agreed was the 5 late fees that she paid, $625. That's for failure on the 5 CCDRs. Next position, David Sampson, case 23-0003. He was a candidate for state rep seat 153. He also timely filed 2 CCDRs, September 2022 and October 2022. And he agreed to pay a $250 civil penalty and a $250 late fee, totaling $500. Next one is Robert Murphy, case 23-0020. Mr. Murphy was a candidate for the DeKalb Board of Commissioners, Super District 6. He filed a DOI on October 22nd, 2019. However, he never qualified. He withdrew from the race before the primary. However, he had collected several $1,000s in contributions. He was missing 2 CCDRs for June 30th, 2020, and also January 31st, 2021. He was extremely cooperative, filed those missing reports and his banking records, provided those to the staff, and it showed that he had actually refunded those contributions. So he'd done the things he needed to other than file the reports. He agreed to a consent of $250, which is a $125 civil penalty and $125 late fee. Next is Shelley Hutchinson, case 22-0170. Ms. Hutchinson was a candidate for General Assembly, for State Rep seat 106. She was the incumbent, and she won that election. She was missing for September 30th and October 25th CCDRs from 2022. All her reports are up to date as of now, and she agreed to a $500 civil penalty and for those 2 violations. Position 6, Stephanie Woodard, case 22-0157. She was a candidate for re-election to Solicitor General of Hall County. She, I think, was originally appointed in 2008, and then through subsequent years she was re-elected these various times. She currently is the Solicitor General. She had ultimately, I worked with working with her attorney, going through bank records that they provided, correcting things. She's agreed to 1 late person PFDS and 7 missing CCDRs. 2 were from 2022 from the election year for April 30th and June 30th, 2022. And there were 5 from non-election years, being December 2019, June 2020, December 2020, June 2021, and December 2021. She agreed to consent for those violations with a $3,000 civil penalty and $1,000 in late fees. Angela Moore is the next one. It's case 22-0169. Ms. Moore was a candidate for General Assembly for House seat 91. She won that election. She was missing 4 CCDRs from April, June, September, and October of 2022. She had only raised a total in the entire election of approximately $3,852, and she was missing a personal financial disclosure statement. She agreed to those violations with the consent for $500 in civil penalty and $500 late fee, totaling $1,000. And finally, Lauren Alexander, case 23-0010. She was a candidate for DeKalb Board of Commissioners, District 2. She lost in the primary runoff. She was missing 3 CCDRs for her election for September, October, and December of 2022. And she had a PFDS that was not timely filed. Those issues have been corrected. She immediately contacted staff and worked to resolve these immediately upon receiving the complaint. She agreed to consent $375 civil penalty and $125 late fee for a total of $500. That concludes my consent.
Thank you. I just want to note that I think, again, it's something to say, it's very positive with the commission staff that, all these cases, with the exception of 1, I believe, we're all 22 and 23 cases. So we're seeing that we worked through the backlog that certainly existed with some of these cases at some point in time. Do we have any, excuse me, questions, comments, or concerns for any of the commission staff with regard to these consent orders?
I have just one question for Mr. Baywall. On the City of Mapleton case, my firm had its own IT issues all day Friday, so I couldn't pull up the code. But a candidate can make contribution. After an election, a candidate can make contributions to another candidate. That's perfectly appropriate. But it's the ballot committee that can't do that under the code section you cited. Is that correct? Is that how I? So they can only do the other two, the return it or do a charitable contribution.
Yes, sir.
Okay.
21.533, it has, I think, 5 sections to it, and the main section deals with an individual campaign, what they can do with excess contributions. They can carry it over, they can donate it, they can return it pro rata. They have options with how they can expend that money. And the ballot committees have their own designated section. It's the last section in 21.533, and they have that limitation. It's either donate it to charity or return it to the donor's pro rata.
Okay, thank you.
Mr. Hicks? Mr. Chairman, I have a question and a comment. We can wait until after the vote, but it's related to this area. I don't know how you want to handle it.
Okay. We'll address that in 1 second. Do we have any other questions, comments, or concerns with regard to the consent orders that have been proposed? Hearing none, do I have a motion?
So moved.
Got a motion and a second. Any discussion?
Move to accept.
Yeah.
Move to accept.
Yeah.
Right. He said so moved, so I don't. Mr. Well,
No.
I thought that it popped back up, but anyway, all right. We got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor, say aye.
Aye.
Any opposed? All right. All those consent orders will be approved. Mr. Hicks?
So my question and comment, Mr. Beck, is that a lot of times you hear people ask the question as it relates to staff auditing. How does that happen? Is it bias? Is it political? Tell us how you do that, and if you're doing it differently, tell us how that process works so that folks can be clear about the process.
Right. So as of right now, the way we audit, we will pick out municipalities. Now, we don't pick it out based on any set criteria or anything like that. We just move around the state, basically. Whether this last audit was DeKalb, the previous one, I believe, we've done Fayette, we have done City of Atlanta, we've done Gwinnett, we've gone all the way up north to Gilmer, Lumpkin, counties up north. So we just sort of move around the state and try to pick geographical areas that are similar politically or population-wise. So that's how we've done it in the past. Moving forward, the interesting part about our new system with filing system is we're able to pick out audits. We can just audit random, everybody who is registered in our system. We can just click 5% or 10%, and it will pick out just at random those candidates to audit. And so that's how we've done that in terms of the candidates who are registered in our system. The locals is a little tougher because those candidates aren't in our system. So we sort of have to pick and choose and use that certain criteria because we don't want to be seen like we're picking on one side over the other. So we just sort of move around and sort of base our audits off of that. I will say that the DeKalb one was kind of interesting because we noticed that they hadn't paid late fees in about 4 years. Their candidates hadn't. And so when you think of one of the most populous counties in Georgia, the candidates just not having incurred a late fee. You would like to think everyone's compliant, but of course, after we audit, we realize, oh wow, there are a ton of candidates who just didn't file certain reports or are missing a whole election year worth of reports. So part of the audit process is going in, doing that, letting people know we're watching so that they ultimately file these reports and we can sort of increase compliance. In the future, if we do somehow have local candidates come under our filing umbrella on our system, that audit system, the audit system we can use right now, would be able to just pick out 5% of the candidates at random. It's going to go through and list some violations that are misreports, excess contribution limits, maybe not filed in the right time period, contributions or expenditures not filed in the right time period, things like that. So that is something, if we do eventually bring that power back to the commission or bring those filing obligations back to the commission, our audits are going to look a lot simpler and a lot more diverse in that we're going to have anywhere from governor on down to the local quarter. So that's something interesting I think that this new system can do that we didn't really have the power to previously do. So that's how those are sort of handled.
Just a follow-up question. So as it relates to the locals, where they're not integrated in our system, they don't file with us, in the interim, is there any reasonable software out there that will allow us to randomly, you plug in all of their names and then randomly sample them as well? Have you looked at that?
I'll take that,
Yeah.
actually. And I'm going to answer your question, Commissioner Hicks, but first I want to clarify what Mr. Cusack said. When we were still in the old system and we would randomly audit, we would, we have IT staff that would essentially in that system sort of Rolodex and pick it out. And what we ensured we did is if we had a big Republican county in terms of size, geography, we'd make sure that there was a corresponding Democratic, entity. So if you look at the history of our audits, they're pretty balanced. And the best we were able to do at the time. With a new system that truly does it for us, it's much better. There is some software to your point that we've been looking into. Before I make a decision to spend the money to purchase one of those for the locals, I do want to see what's going to happen next session because there was some momentum this year to bring the locals back. And so before I start spending a significant amount of money, I want to see if that actually comes to fruition. And if not, I think we'll be ready to move forward.
Sure, and that's fair enough. I just, as one of the commissioners, you always get that question.
Sure.
Wait a minute, am I being targeted?
Right.
And I think the way to eliminate that is to make it as objective as possible. And I think a software or some system, ideally to get them all back into our system.
Right.
The way to go.
I completely agree.
Thank you.
All right. All that being said, we'll go ahead and move to item 7 on the agenda. We've got administrative dismissals for A through L. So, Mr. Cusack, you're starting on that.
Yeah, Mr. Chairman, I know we normally just leave the administrative dismissals silent if anyone has an issue to bring them up. I thought there was a couple of things in terms of the administrative dismissals times that commissioners would like to know. We are required each fiscal year to do a case count, and it normally falls on the Deputy Executive Secretary to complete that case count of ultimately what is going on in the commission, how many cases we're closing, how many are open, how many are older than 2 years, and we submit that to the state accounting office. This year was the first year I've done that. I had a lot of help from Ms. Easterwood and Ms. Gordon in our office in finding these cases, some that have never made it into our filing system, that have, and if you look on the agenda for these cases, some of them are fairly old. They have aged significantly. So that was part of the case count that I did in going back, and we figured out that there are about 25 to 35 cases that were still open dating back to 2010, in which no decision had been made on these cases, and these cases were still pending. And they were assigned to various lawyers who are no longer employed by the commission. So since that case count was conducted, over the next meeting and probably the meeting following that, we're going to be making decisions on these cases. More than likely, it will show up as administrative dismissals, but some in which we can move forward on, we will. But we are now looking through all of these cases, and that should bring our backlog current. Like Mr. Chairman said, all the cases we're moving forward on are relatively new. We are moving forward with those. It's these cases that did not, for whatever reason, subpoenas were sent, nothing was ever followed up on, that we have now gone through and are working through those, and that's going to bring our case count very current. We've also instituted a new policy on any case that is over 2 years old. We are going to meet as lawyers and as staff quarterly to go over any case that is 2 years old to figure out what needs to be done on this to move it forward. Does it need to be administratively dismissed? Do subpoenas need to be sent? What is the status so we can ultimately close these cases out in a timely fashion? So that is something new going forward that we're going to be doing so that something like this doesn't happen again.
What exactly is the process that the staff follows when we have an attorney leave the commission to make sure that we don't have cases that just end up sitting there?
So as of, we try to conduct, or at least have a list they give a list of an update. It's easier now. We have, in 2020, we got a new case management system. So you can just run a list of what cases are assigned to each lawyer. What happens is the cases pre-2020, that's where the issue is, because they're never entered into really a case management system that you can chronicle. They're just folders. And so that's, it seems that some could have slipped through the cracks pre-2020. Now we can, conduct that list. So it's much easier now with the new lawyers because everything is on that case management system. But this shouldn't have happened. These cases shouldn't have languished this long. Decisions should have been made on them. And so we're fixing that right now, and going forward, basically everything is going to be have fresh new case numbers that we're going to be moving forward on.
Commissioner Wise?
Yeah, let me just understand. There's just no action on these. You're just, for whatever reason, you're dismissing.
Some of these, service was never affected on the respondent, so we never received a response. They were never mailed. We never could prove that they had received this mail, that they knew a complaint was against them. Some have subpoenas sent, complaints been filed, or subpoenas been sent, subpoenas been returned, and then for whatever reason the case is just sat in a holding pattern. So it's a little bit of both.
So they're almost just aged out?
Correct. Most of them are really aged out. It's going to be tough to get evidence on most of these, but at the very least, we're going to at least give closure to the complainant and respondent on these.
And I'll clarify a little further. Some of these just have statute of limitations problems because service is never affected and complaints are never officially docketed. I'll say that when I took over in 2019, we had a backlog of hundreds of cases. Chairman Crandall remembers hundreds and hundreds of old cases. This should be the last wave, and we're talking about 20 or 30, knock on wood. But to Commissioner Wise's point, the process of new lawyer, or to the chairman's point, when lawyers come and go, now with the new filing system, we can automatically redirect and reassign those. And I think we implemented that within the first 6 months that I was here. Prior to that, it was basically folders and sticky notes, and not a very effective system to make sure nothing slips through the cracks. So that shouldn't happen moving forward, but I think we're holistically in a pretty good place.
And again, for Commissioner Wise's benefit, the way that we generally address these is that if anyone has a question or a comment on these, when we get to that part of the agenda, you can raise it at that point, but there's no action to actually be taken by the commission. Right. Yeah. And what Mr. Monty said is that once he signs it, it's already closed. That's why there's no action to actually be taken on it. So does any of the commission staff, does it have any further comments or anything with respect to the administrative dismissals? All right. Any questions, concerns, comments, anything from any of the commissioners on that? All right, we'll go ahead and move then to the next item on the agenda, which are compliance orders. Mr. Cusack, this looks like it's yours as well.
Yes, this is a compliance order. It's been a while since we've had one of these. A compliance order, just for everyone's edification, is an order in which there is no fine. There is a violation, but there is ultimately no fine. We sort of use it more as an educational sort of endeavor, an educational order, if you will. But this one's a little unique in that Ms. Deborah Fisher actually filed a complaint on herself. Ms. Fisher is a commissioner, I believe, in Grovetown, and is running for mayor of Grovetown now. She went to her elections office and asked if she needed to file a new DOI, and they told her no. And then she started making some expenditures with her own money, about $300 worth, for her mayoral campaign. A week and a half later, she received a call from the elections office saying she did in fact have to file a DOI. She was horrified that she had violated the law and ultimately filed her DOI and then filed this complaint against herself. And she wanted to make sure she was in compliance and that everyone knew that she had thought she was doing everything right. So this is one of the times where technically she did make a pre-DOI contribution expenditure, But in this matter, we're sort of exercising some discretion and not fining her for the violation. And I think this is, we don't do compliance orders a lot, but I believe given her telling on herself, basically, she deserves a bit of grace. And so this is why we're choosing to not fine her and using this sort of as an educational opportunity for her. She was very sweet on the phone. Right away, I called her, let her know this is how we would handle the case. And I think this is one of those appropriate times to issue a compliance order in this case as opposed to a fine.
And I will tell everyone historically, I've been opposed to these types of compliance orders, but now we've been presented with a set of facts where I think that we would agree with this particular order, especially because she was given the incorrect information from the local person with respect to the filing requirements. So, I'll go ahead and, is there any further discussion, comments on this? Is there a motion with respect to the compliance order?
I move to approve.
We've got a motion, do we have a second?
Second.
Got a motion and a second, any discussion? Hearing none, I'll call the question, all in favor say aye. Aye. Any opposed? All right, that compliance order will be approved. Next on the agenda, we've got item 9. So a rule change for consideration. Is that going to be you, Mr. Cusack?
Yes. This has to do with a repeal of a rule. So in our quest to sort of clean up our rules and make it easier to read, make it make sense and make it work with our law, this is Rule 189-1-.07, which is the adjustment of contribution limits based upon inflation. The rule used to state that we had to do this every year. I think most of y'all will remember at the beginning of the year we adjusted the contribution limits because OCGA 21.541K directs the commission now, after every gubernatorial cycle, to go ahead and adjust the contribution limits based on inflation. So given that the statute now gives us clear direction on when we are supposed to do this timing-wise, this rule no longer applies. It's in contradiction to what the statute says, so we are repealing this rule so that there's no question of when the timing of when we adjust the contribution limits is. Since the statute would trump the rule anyways, there's no need for this to be there, and we can go ahead and repeal this rule. So that is why this is on this calendar, and we're going to try to clean up as many rules as we can for the meetings going forward. So this is sort of helping us with that quest of cleaning up our rules for the agency.
All right, thank you, Mr. Cusack, for your presentation there. Do we have any questions or concerns with respect to the repeal of this rule?
I move to approve, move forward on the repeal.
One quick question.
Well, I think there's a motion on the floor. We need a second. All right, we got a motion and a second. Any discussion?
I'm in support of it. Is the statute sufficiently detailed that we don't need a rule to implement it? I know we voted on it, it looked pretty clear to me, but I just wanted, will we need to adopt a rule to implement the new procedure?
No, the statute, it was rewritten. I think Mr. Amati went to the General Assembly and said it was unclear. And so now it explicitly says, after the first meeting after the gubernatorial cycle ends at the beginning of the year, that's when these limits are to be revisited.
Right.
So it is explicitly clear now.
Any further discussion with respect to the motion? Hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? So that motion will also carry. Is everyone good at this point? I know we've been going through without a break. It's about 11:30. Everybody good? We're being very efficient with our agenda this morning. We're going to move to item number 10 on the agenda, which are 2 advisory opinions that the staff have proposed for us. Mr. Cusack, are you handling both of these?
Yes, I am.
All right. I'm going to go ahead then and for item A, I'm going to, I guess, to call for discussion of the advisory opinion 2023-01, caregiving expenses.
This is advisory opinion 2023-01, which poses the question. It's a fairly simple, straightforward question. I'll go into the question actually presented, but are caregiving expenses defined as direct care, protection, and supervision of a child or other person with a disability or a medical condition for which a candidate has direct caregiving responsibility incurred as a direct result of a campaign activity or holding public office deemed a permissible campaign expenditure in the state of Georgia. So this was a question of first impression for the commission. The FEC has taken up this question on caregiving expenses by campaigns a couple times and has ruled that it is an ordinary and necessary expense and that campaigns are given the permission to utilize campaign funds for caregiving expenses. This advisory opinion does just that. It allows caregiving expenses here to be utilized by campaigns for campaign-related purposes or for fulfillment of their public office. We have looked at sort of what our definition of ordinary and necessary expenses are, and we are able to give it a pretty broad, expansive definition. And so using that guidance, we're able to determine that this is an ordinary and necessary expense for campaigns, if they so choose to incur it. I will say we did make a note on this that there are some tax implications that falls out of the commission's purview, so we went ahead and said, be mindful of that. We're not going to make any determinations how you disclose it, but just be mindful that there could be. I'm a new parent, so I know there are some tax implications involved in daycare, so I wanted to at least stick that in there. But this was one of the advisory opinions. They normally aren't fun to write, but this one was, I think, one that I greatly enjoyed writing. I think it's good policy to enact this.
And again, I've always historically been of the opinion that some of our, advisory opinions have been, way too long, included much more information, than necessary. So I had highlighted that paragraph regarding, tax implications and why we were going to include that. But I guess it's my understanding, and you tell me if I'm wrong on this, that we've got, other advisory opinions that have been issued where we've included that as well, just in case a tax issue came up that the individual couldn't say, well, the commission approved this.
Correct. And I actually spoke to Commissioner Hicks about this, trying to get a better understanding. But that was something that I thought was important to get in there. But we make the determination on some other advisory opinions. There are other implications elsewhere that could fall under this. So we sort of put that in there as cautionary language, just so they can't come back and say, well, the commission said this is okay, so I did it. So we're at least saying, there are stuff to be aware of here that falls outside the Campaign Finance Act. Just be aware.
Okay. The one other thing that I did note with respect to the advisory opinion, and I guess we'll just include this, in the motion. There is what I believe to be a scrivener's error in this. If you look on page 2 of 3, and again, this is not being critical. I think this is, again, well written. But I think that the third paragraph in that, the third sentence in that paragraph says nothing in this opinion should be construed to allow campaign funds to be utilized for child or dependent care when the cost is incurred by non-campaign or non-public office activities. I don't think that those can actually incur the cost, and I think what this was intended to say is nothing in this opinion should be construed to allow campaign funds to be utilized for child or dependent care when the cost is incurred due to non-campaign or non-public office activities. Isn't that the way it was intended to?
Yes, that was.
Okay, all right. And again, I welcome any discussion, among the commissioners on this, but again, because it's a scrivener's error, and I don't think it creates any material change with respect to the advisory opinion. So again, if anyone wants to correct me on that or their thoughts, I welcome that. Commissioner Wise?
Clarify what's an advisory opinion as opposed to, is it okay or not okay to?
So in advisory opinion, there's certain ways campaigns can communicate with us and ask for, I guess, off-the-record advice, or not so much off the record, or how we would interpret this, sort of informal advice. we could have handled it this way. If a campaign called and said, how would y'all interpret this? Would caregiving expenses be a ordinary and necessary expense? We could give them the answer and say, yes, they would. Just properly disclose them. The commission would determine that. But this is actually formal guidance for campaigns. So they can actually submit a formal question on how the commission would interpret this, or a specific question or set of facts. So they have that to then say, there's formal guidance from the commission that says this is okay.
So where does it stop? If it's okay with caregiving expenses, you could make a justification that I'm a commission salesman and my family's not eating because I'm not working and I'm running for public office, and I realize that's a commitment that people make, and there's a discomfort to offering yourself up for election. But how about food expenses or mortgage or health care? At what point does that stop?
So I think we would answer,
Well, the personal acts, talk about personal
yeah, there is a provision in the act that talks about campaign contributions can't be personal assets. They can never be converted to personal assets. So under that hypothetical, food is a tough one, because if you are, say, a statewide candidate, you're out on the road campaigning, you need to stop for a meal because you're out campaigning, that is an ordinary necessary expense. Now, if you're at
Yeah,
home,
but I'm going deeper than that. As
Right.
opposed to caregiving expenses, my children are hungry because I'm not working, I'm in, pay higher. So how does that work there? In my case, I always had a wife that went to work every day, so I could be on the road campaigning, but at the same time, it did affect our family. And I could make a case that we were harmed by my offering up for public service.
so under what would they be trying to do? Would you be trying to reimburse yourself for
Sure.
for what expenses?
I don't know. I'm just saying that I think there's an issue here, that where does it stop? I'm not saying that it should be for mortgage and food
Right.
and healthcare. I'm just saying if caregiving, child care, is an appropriate expense.
And I think there's a big differentiation between the caregiving here is incurred because of campaign-related activities or public office-related activities. That is where it stops. So if you are a part-time legislator, part-time councilman, part-time elected official, when you are doing something related to the campaign, then you are authorized to expend campaign funds on childcare. Where you aren't allowed to is in your personal life. So if you have you're under the hypothetical there, it's a part-time salesman.
But caregiving is every bit as personal as feeding your family. And it's for the same children. So how do you differentiate the difference between feeding your kids or having them taken care of in daycare?
So I think feeding your kids is wholly a personal expense. You're going to incur. Okay, Mr. Meyer.
So in the language of this AO and a lot of our AOs, we talk about the concept of the but-for test. So, to your question, will, at some point sacrifice, what about paying for my health insurance, paying for my kids' food? Your kids are going to have to eat anyways. You're buying food for your kids whether you're in office or not. Here, the caregiving is not all caregiving. It's specific to a situation where I wouldn't have to.
It's not in office, it's while you're campaigning.
Right.
To be in office.
Right. The argument it becomes, I would not have to pay for this expense if I were not in office or running for office. That's the but-for test. Now, where it is different than, you asked about caregiving, you can't pay yourself to caregive. So you're benefiting by buying your own food. You're personally benefiting by paying for your insurance. But you're not personally benefiting taking campaign money and paying a nursery service or a sitter to babysit for 2 hours while you're in the chamber. That's sort of I don't want to call it a bright line because it's very fact specific and there's some gray there, but that's sort of the dividing line between where it stops.
And I'll add to this because I actually made a note of something similar to that when I noticed the scrivener's error in there, which is that, this advisory opinion, it doesn't actually set forth specific facts and what will happen, as a standard with regard to specific facts like what you're talking about. This is just, again, affirming what I believe to be the but-for test, and that it will then fall back on, every candidate to be able to explain how what they did, if they use campaign funds for that, how that meets the but-for test.
I have a question.
And I'm sorry, I saw your thing. Go ahead.
So did the federal commission address that kind of concern, the abilities for candidates to take it to the limits as it relates to child care expenses?
They just blessed that childcare expenses are an ordinary necessary expense. It's just a narrow question, narrow answer to that question. I think when it comes to wholly personal expenses, they can't say they allow that. They're not going to catch everyone, but they also are very, I'll use for example, there was a congressman in California who was using campaign funds to pay for his kids' private school tuition, and he ended up going to prison for that, and the FEC fined him for that. So stuff like that, they draw the bright line on, but certain questions like this just related to this narrow issue, they're saying it is a ordinary necessary campaign expense, and you can make that expense if you so choose.
Yeah, well, once again, I'm sorry.
Go ahead.
The issue that just struck me would a candidate who had been paying caregiving expenses prior to running for office then have expenses paid by the campaign, as opposed to somebody that wasn't paying caregiving expenses, started the campaign, and then began to make those expenses to the campaign? So there's a clear difference there. If somebody was a stay-at-home mom, runs for office, and then makes a claim, I could see that. But if somebody was already paying caregiving expenses in the day-to-day, then runs for office, and then said, gee, I've got this pot of gold.
So that's the but-for test. And so in that scenario, no. An analogy we get a lot is, can I use campaign money to join the Rotary Club or the Chamber of Commerce? And the answer we give is, well, if this is something you're now doing because you're in office, that it relates to your office. If you've been in the Rotary for 20 years, you don't get to suddenly start writing a person, a campaign check that you were doing anyways.
Well, I'm sure I'm asking rookie questions.
No. But to your point, you're exactly right. If you're already incurring that expense, then it's not truly related to serving in office.
That makes sense.
And again, my personal opinion is that one of the reasons this AO is so important is that it did differ from what the feds had already recognized, and so we need to actually I think spell out that we're going along with that federal rule as well. Some people could argue that if we didn't issue this particular AO, that once presented, that we could be taking a position that would be different than what the federal folks are doing. Were there any written submissions with regard to the AO?
Yes, there was, Mr. Chairman. We normally don't get any written submissions for advisory opinions, but this one we got it from the Vote Mama Foundation. It was maybe I'm butchering this pronunciation, but I believe Liuba Shirley, who ran for the U.S. House in 2018, and actually submitted the advisory opinion question for one of these to the FEC. And from what I understand is this organization encourages mothers and caregivers to run for office, and so they are in support of our interpretation of this. And I found it to be an informative letter, and just looking at their mission to be something interesting and additive to this discussion.
Okay.
And you all have a copy of that letter in your blue packet.
Yeah. And since this is, an advisory opinion, we send out notice of it and whatnot. I'm going to go ahead and open, for the floor. Does anyone wish to up here with regard to any comments, questions, concerns with this AO.
I'll notice my representative, Evans, is here.
Mine too, actually.
So she is the petitioner on the question.
Right.
Hopefully I won't mess up with these constituents in the room here.
Go ahead and just for the record, just go ahead and introduce yourself.
Sure. Thank you, Mr. Chairman and Commissioners. Stacey Evans. I'm the state representative for District 57, parts of the city of Atlanta. And along with Representative Beth Camp, we submitted the letter to the commission to consider this advisory opinion. And we really appreciate the commissioners taking this up today and the thoughtful discussion that's taking place here today. And as has been shared, this is something that the FEC has issued an opinion in this regard on. But I also want, for comfort to the commissioners, to understand 22 other states do this currently. There is either ethics action or legislation pending in 11 other states. And of those 22 states that have moved forward either with ethics commission guidance on this or a piece of legislation, there's a lot of our southern sisters with us. Texas, I don't have my reading glasses and I'm getting older. So Texas, Alabama, Louisiana, Tennessee, Kentucky, Virginia, Arkansas. So we certainly are not alone, and this has been taking place over a number of years. So to Commissioner Wise's concerns, I just wanted to share that to date we don't have any evidence that we're aware of where people are abusing this or using it to supplant things that they would pay for anyway. And for all candidates, we would always keep in mind what would the public say. And I think that if anyone tried to abuse this, it certainly would likely not go over very well. I'm excited that this step is potentially being taken today. You might notice there's not as many legislators serving with young children, particularly women, but I want to be clear this is something that single dads or dads could use as well as women. We appreciate the support from Vote Mama, but this is definitely a parent issue, not just a woman or mother issue. So thank you so much for the consideration.
Thank you. Ms. Young, do you think we've got any issue, with respect to the correction of the one Scrivener's error in the notice that we required or anything?
I think as long as it's appropriately documented in the minutes and the final version of the AO does not contain that Scrivener's error, I think that's fine.
Okay.
As long as the vote is clearly to adopt it with that correction.
Okay. Any further discussion from the public? Yes, ma'am. Again, if you'll just identify yourself at the podium, just so we have it for the record.
Thank you for the time. My name is Uriah Hamley. I run for Georgia State Senate for District 33. And I think this is not just for the mothers, people with children. When I was running, my dad had an open heart surgery. And the whole time I was running, I was driving to Kennesaw Hospital every morning to check on my dad and every evening to check on my dad. And I think this is a little bit personal for me because it's not just the parents. It's for anyone that have someone in your life that is disabled and you're actually running a race and doing everything on your own. So I think this is a blessing that someone proposed this and whatever we can do to see it through. Thank you. It's a little bit emotional, but thanks for your time.
Thank you, ma'am. Any further questions, comments, concerns with regard to the AO? Do we have a motion? Oh.
I just want to say in response to Commissioner Wise's comments, I've pondered the same issues and I've wrestled over my year with the but-for test, and it takes a while to get your arms around it, and it can be as solid as Jell-O at times. But in my mind, this falls under the same category as housing and food and transportation that candidates occur while they're campaigning or when they're in session, and that's okay. And then when they're not doing that, it's not okay. And I like the paragraph in our AO that good record keeping is critical. I suspect a lot of officials have to keep a vehicle log. Now, not everyone does that, but that's how I hang my hat on supporting this.
Thank you, Commissioner. Do we have a motion with respect to the, to AO number 2023-01?
I move to approve with the edit of by to due to on the last sentence of the second page.
So moved.
So we got a motion, we have a motion. Any second?
Second.
And again, the second is to the AO with the correction of the scrivener's error. We got a motion and a second. Is there any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye.
Aye.
Any opposed? All right, that's adopted. We'll next move forward to advisory opinion 2023-02.
Advisory opinion 2023-02 is a request from the Libertarian Party of Georgia made by Brian Sells on their behalf. And it asks two questions. It asks, is a candidate nominated by the Libertarian Party entitled to a primary contribution and primary runoff contribution, even though the Libertarian Party is not permitted to nominate candidates by primary election due to their status as a political body? The second question is, contribution limits do not apply to political parties when a contribution is made by a political party in support of the party ticket or group of named candidates. Do the contribution limits apply when the Libertarian Party contributes in support of its party ticket or a group of named candidates? This is really deep into the election law portion of the code and subsequent other sections, but the Libertarian Party isn't actually under the election code, how the Secretary of State defines it, considered a political party. They are considered a political body. Basically, they didn't, to be a political party, and the definition is in the advisory opinion, any political organization has to, in the last gubernatorial election, nominated a candidate for governor or had their candidate for governor at such election poll at least 20% of the total vote cast in the state. Or, to be considered a political party, during the presidential election, they nominated a candidate for president of the United States, and their candidates for presidential electors polled at least 20% of the total vote cast in the nation for that office. So under the current structure in the Secretary of State's portion of the election code, not our election code, or not the Campaign Finance Act, has the Libertarians as a political body. So they fall under this, this political body definition. Political bodies cannot nominate their candidates in a primary election. They can only nominate their candidates by convention for statewide public office. For any other local election, for state house, state senate, they would have to gather signatures to ultimately get their way on the ballot. But for statewide elections, they can nominate, since they received more than 1% of the vote, they have to nominate their candidates by a convention. And what happens at that convention is they basically pick a slate of nominees for each statewide office, if they so choose, and then those people run as the Libertarian Party ticket. It's a little bit strange in that we're used to very much the primary system, but that is how ultimately a Libertarian or third-party candidate makes their way on the ballot in the state. The Campaign Finance Act is actually silent on this. It very much considers only the primary system, sort of the two-party system in the Campaign Finance Act and the contribution structure. So the first question, is a candidate nominated by the Libertarian Party entitled to a primary contribution and primary runoff contribution, even though the Libertarian Party is not permitted to nominate candidates by primary election due to their status as a political body? The Campaign Finance Act is silent to that. However, we then go to our rules and regulations, which actually has a rule on point, and that rule is Rule 189-6-.02. And that rule states, or that rule applies to candidates who appear on the general election ballot, but not on the primary election ballot. This rule was enacted in 2001 and then subsequently amended in 2008. I will say I have gone back through the minutes for all the meetings for those years and tried to figure out why this rule was enacted. And Chapter 6 was enacted just by unanimous vote in 2001. There was no notes, discussion, anything like that. Chapter 6 was just voted on and established in 2001. So there was nothing there that gave us any guidance on why this was established in 2001. In 2008, the vote actually doesn't exist in any of the minutes then for why this was enacted. Could not find it anywhere. I think one of our commissioners may have been around then. But I didn't find any notes on that as to what was amended or what exactly was the reason behind it. But the rule states any person who will be on the general election ballot as a candidate in an election preceded by a primary election may accept contributions designated for such primary election, even though such candidate does not appear on the primary ballot. Using that rule as guidance, it appears that a Libertarian candidate would be entitled to a primary and a general contribution under this guidance. I do not believe they would be entitled to a primary runoff contribution. The Act is very clear on if you aren't going to be in the primary runoff, the money goes back, any contribution raised for that goes back to the donors. So it's an impossibility that they would actually be on the primary runoff ballot because they're not appearing on the primary ballot. So I think it's safe to say that they are not entitled to a primary runoff contribution. However, given this rule, it does appear that they are entitled to a contribution for the primary and general, although they do not appear on the primary ballot. So that is where the answer falls down for us because of this rule. It's a little strange in that it doesn't appear right that you're not in an election, a primary election, and you should be able to raise for that. But that's given the rule we have now, and this is probably more of a reason we should clean up these rules. It does appear that they would be entitled to a primary and general election contribution here.
I don't want to interrupt you, but that's all been my concern, from the very beginning on this, is that because I have these notes written down about, I want to know what the history is behind the rule and why there was, the amendment in 2008. And I understand, we're talking about a long time ago, at this point. There are a number of statutes that are cited as supporting authority, for the rule. I looked through those and I didn't see anything, and now I believe I'm hearing you say that the Campaign Finance Act is actually silent on the issue. So I guess the one thing that I wanted to point out with regard to this is that the question today is not whether the rule should be in place. The question today is, under the rule and laws as they exist, what's the necessary answer, to this question? And considering that rule exists at this point, again, I agree with the ultimate conclusion that is given here, and it is only because that rule exists. And so, I would just state, for record purposes, that if we move forward, with changing the rule, withdrawing the rule, or what have you, that I believe it wouldn't even, this is just, again, what I think about this, because this advisory opinion relies so heavily on that rule, that if that rule changes, I don't even think it would be necessary to formally withdraw the advisory opinion. I think it should just be obvious enough for everyone to know that, well, that advisory opinion was written the way that it was at that time because this is what the rule said. Again, we can certainly address the issue down the road in the event that we, change that rule, in some regard. So
yeah, and in looking at the way, I know there were elections in which the election ultimately gets canceled when one candidate qualifies and it passes the write-in period. We have always said that they're entitled to the contribution for that election because they were going to appear on the ballot. I'm not sure exactly how this rule applies today and why it should be in place. So if that's something we want to visit down the line, I think that might be appropriate.
and again, I got sidetracked on that to some degree. With regard to those statutes that are cited after the rule, have any of those changed in any, pertinent, in any pertinent regard? In other words, was there statutory support for the rule as it was written and amended back in 2001 or 2008?
I'm sure there was in 2008.
I'm waiting for you to shed light and information on this issue.
I was surprised that, it wasn't.
So there was a recession?
Was there? Okay.
That's all we.
We couldn't afford court reporter.
Couldn't afford the court report.
We couldn't afford paper. My computer system wasn't working. I have no idea.
Any further questions, comments from commissioners with regard to this advisory opinion?
Would you like me to talk about question 2?
I do, I'm sorry.
And that one's fairly straightforward.
Yes.
The political, I'll lay out the question. Contribution limits do not apply to political parties when a contribution is made by a political party in support of the party ticket or group of named candidates. Do the contribution limits apply when the Libertarian Party contributes in support of its party ticket or a group of named candidates? The political party definition in the election code and how it differs from how it is defined in the Act. Ours is much more broad. I believe that's on purpose. And so we made this determination because it is such a broad definition that they are authorized to make contributions or expenditures to a group of candidates or a party ticket and are not bound by the contribution limits for the contributions or expenditures. And that just comes back to a level playing field for everyone. So that's I think, based on our political party section being so broad, that's why we're able to make that determination as opposed to the narrowing in the election code for the Secretary of State.
And again, that's actually in the statute.
Yes, yes, that is by statute.
Right. Now, are there any further questions, comments from any of the commissioners with regard to the proposed advisory opinion? I don't hear any. I'm going to go ahead and again, since we had the notice that went out, I'm going to open it up to the public to make any questions, comments, or concerns with regard to the proposed AO as well. All right, I don't hear any. Do I have a motion?
Motion to approve.
Second.
I got a motion and a second. Is there any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye.
Aye.
Any opposed? All right, that advisory opinion is also approved and adopted. All right. Former Commissioner Watt's favorite part of the agenda is agenda item number 11. Mr. Imadi, do you want to go ahead and proceed with that?
Sure. I'll actually, in honor of Bob not being here, I'll be brief for once. Something we talked about, several commissioners and I talked about recently. We have an education and training division. This commission is not all stick. We try and help and prevent violations and inform, especially at the local level where there's just less sophistication around a lot of these. And when COVID hit, that really shut down our ability to travel throughout the state for a couple of years. And we did things like the virtual chats and sort of the online stuff. But in my experience, there's nothing near as effective as being in the room with local election officials, with local candidates, and dialoguing and answering their questions one-on-one. So as of last week, we are now fully staffed in the education division again. We had some turnover there. We had to hold off on some hiring to make sure the budget was tight. We are now fully staffed with multiple trainers, and we are launching over the next year and a half, a statewide education blitz. We're going to be going to several, big cities and municipalities and inviting, 10, 15, 20 counties and cities in the nearby area for a day-long training session. And I'll get to a little bit of that when we talk about changing a couple meeting dates for the rest of the year. But we're looking to really sink our teeth in and do a much more efficient job of educating and training throughout the state. To that end, we have the newest member of our staff. She's not over here today, but Reagan Costin is our newest education trainer. Ms. Brown oversees that division, along with Ms. Thatcher, who I think has been introduced to everyone here. And we're going to be putting some real resources into doing a lot more hitting the road and training throughout the state. That said, that's really all I have, Mr. Chairman.
Mr. Thompson?
So I know in the past, there's been issues when people were out training, trainers giving out wrong information.
Right.
Can you just talk briefly on how you're making sure that it's consistent and that they actually know what they're talking about? Because that's what caused much confusion.
Sure.
And I would see compliance orders coming out after that.
Right. So most of that happened before I came on, but I was familiar maybe the first year where that was happening. The short and dirty answer to your question is Mr. Brown and Mr. Cusack are going to be present at all the, one or the other, or both are going to be present at all the trainings to make sure we have someone who, at a high level of the staff, understands and makes sure we're getting out good information. And it may not just be Mr. Cusack. We've got, Mr. Faywell, Mr. Canoe, we've got an open attorney spot, but legal is going to be much more involved in education than it was sort of in the earlier iteration. And I think that should address the concerns and the issues we were having.
Do we have any of those statewide training sessions, sort of nailed down at this point?
So tentatively, I'm going to propose that we relocate and change the dates of our September, December commission meetings, and that we actually, because I know several elected officials that have put some of you on the board, have expressed to me that they want this commission to represent more than just inside 285. And I think there's a lot of value in having geographic representation throughout the state. And part of that, I think, not just training throughout the state, but taking the commission to different areas in the state and, exposing some of those big cities and counties and the surrounding areas to it. So the first tentative big education blitz, if y'all approve, is going to be a 2-day event where in September, where one day we hold a commission meeting and the other day we have a training in Athens. And we'll invite obviously Athens, Clark County, but Oconee and all the surrounding counties and Social Circle, Covington, or Watkinsville, a lot of the cities around there. And so we're hoping to have big attendance at that Athens education training. From there, we've got ideas. December, I'm thinking Savannah would be a really good opportunity to do another 2-day commission meeting and training session with a lot of the cities and counties. And, they would really break down into 2 training sessions on the training day. One would be for the local election officials who learn a whole different set of information from us. And the other half of the day would be for the local candidates. So Athens is tentatively on the books with y'all's approval. Savannah's one we got in mind. We've talked about Valdosta, we've talked about Columbus, we've talked about Macon, we've talked about some other areas as well.
And I've been a big proponent of this. That's not because we're going to have, possibly have a meeting, in Savannah. I was going to say, this is taking to some degree. I've been driving up here for these years. But no, I think it is very important again that we spread this around the state. Certainly even beyond Savannah. I think that moving it down to Valdosta, to that part of the state would be good, and maybe over the Columbus area or something like that. To also just get our education, especially moving around the state with regard to that as well.
In addition, have you considered ACCG and GMA?
Absolutely. We are going to do a better job in the future of attending those conferences. We used to go to those, and then when COVID hit, kind of shut down for a couple of years, and so we're just now getting back on our feet and involved. But the goal will be to be at ACCG, to be at GMA, to be at the biennial with the legislature, to be at a lot of these conferences that we, the local election officials have conferences. We're going to have a bigger presence at all of that.
All right, Mr. Armani, there was a section also here for new staff.
Well, I mentioned the new trainer,
that's it.
Reagan.
Okay, I just want to make sure that all that was covered. So, all right, with that being said, with regard to the report of the executive director, we'll go ahead and move to item 12. Ms. Young, the report of the Attorney General's office.
Can everybody hear me?
Yes.
Just wanted to update you on our pending federal litigation involving New Georgia Project, which for those that may not recall, or maybe new members here, I'll kind of summarize for you. This is an 11th Circuit case in which we are appealing an order from Judge Calvert in the United States District Court, Northern District of Georgia, that has issued a preliminary injunction against enforcement of the disclosure requirements for independent and ballot committees for not having a major purpose limitation. We have finally, just this morning actually, filed our final brief in that case, so that's fully now briefed and will now just be waiting on the 11th Circuit to issue a ruling on that. Other than that, litigation is actually relatively quiet right now. We have a lot going on the administrative front. I can attest to the increased productivity and efficiency with which things are being ported over to our office, and we will do our best to try to keep up with that pace. A bit of a challenge for us with personnel turnover on our end as well, but we're going to do our best to try to get everything, into the pipeline as fast as we can. And so it does look like it'll be a busy summer over at the Office of State Administrative Hearings. Thanks.
Thank you, Ms. Young. Are there, if the commissioners have any questions of her at this point? Commissioner Burge.
Just one quick one. This is for personal reasons. Do you know the panel for the 11th Circuit?
Not yet.
Okay, thank you.
We have requested oral argument, and if that is granted, we'll have that information at that time.
Anything further? All right, thank you very much, Ms. Young, for your input. All right, Mr. Amati, I think on item 13, you're going to take the lead on that one?
Yeah. So I've kind of sort of already laid out the intent, and it's not, I hate us setting the schedule at the beginning of the year and trying to change it on y'all, midway through, but I really do think this would be something really good for the commission to do. So currently, we have 2 meetings regularly scheduled for the rest of the year. One on Monday, September 18th, and one on Monday, December 4th. I'm proposing moving those to, obviously one in September to Athens and one in December to Savannah. My preferred dates, if it works for y'all's schedules, would be either the 14th or 15th of September. The good thing about these blitzes is it's 2 days, so we can pick which one works better for the commission meeting, and the other will just be the training. So if either the 14th or 15th works for everyone in Athens, we would change that location and date for the next meeting.
Yeah, so September the 15th would be the Friday before the one that's actually scheduled now, right?
Yes.
Okay.
Yes.
And again, I think I don't know what everyone else thinks, but, again, I was a proponent to moving these regular meetings to Mondays or Fridays because I think it's just more convenient for those that may have to travel. So, I think for y'all's purposes, for September the 15th, how would we do, so you're going to have the training on Sunday, the 14th? Or are you going to have the training the day after?
So if we do the meeting on the 15th, we do the training on Thursday, the day before.
Oh, Friday, I'm sorry, yes.
Yeah.
I got mixed up on the day, I'm sorry. Yeah, okay, do we need that, sorry, Commissioner Wise?
I cannot do the meeting on September the 15th. I can do one on the 14th.
And if there's not consensus for that, the other dates we have are people look at the 7th and 8th. We've talked to Athens, Clark County about those dates.
I have no problem with the 7th or 8th, but the 15th is just absolutely out.
Could everyone do the 8th to keep it to a Friday?
Yeah, it's either that, that's fine, but if you wanted to go the other way, I don't know.
I could do
September
it on
14th.
I could do it on the 14th.
And then you can do the training on
I
the
got to
15th.
get out of Dodge.
Fine with me. Obviously fine with us.
Just wait a minute, are we talking about September the 8th, or are we still on 14th?
14th.
Personally, would prefer the 14th.
Okay. Commissioner Thompson Hicks.
I'm fine.
Okay, let's go with that.
So we'll move the September meeting to September 14th, which is a Thursday.
Do we need a formal motion for that?
We
since
do not,
set the
because
other one? Okay.
I set the dates,
That's
so we don't need a motion. If you, with one other commissioner or a majority of non-chair commissioners set the date, I could just willy-nilly change that. But because I chose it, we don't need a vote. So the other one would be, looking at this, instead of December 4th, December 7th or the 8th.
The 8th is the Friday, right?
Yeah.
I think I'm better on that Friday than I am that Thursday.
And to be clear, that would be down in Savannah.
Date is on right now. So-
Right now, it's on the 4th.
But you could do the training on the 7th
And the
and then the
meeting,
meeting on the 8th.
correct.
And we're just there for the meeting day.
Right?
You can come for both, but if you, have other stuff to do, it'd just be me. Oh, really? Or not. All right, so we're good to move that to Friday, December the 8th. And we'll get together about reaching out, and maybe we'll involve you and who in the Savannah, Chatham County area we can reach out to about meeting space.
Because you already have.
We're good in Athens. We've got the Board of Commissioners chamber where you're going to be head of parliament. Yeah, the throne.
All right. Anything further with regard to the meeting dates?
We'll do it.
Next item on the agenda is public comment. Do we have anyone that's signed up for public comment? I don't believe that we do. So do I have a motion under item 15?
So moved. Second.
That's a motion to adjourn. Any discussion? Hearing none, call the question. All in favor, say aye. Aye. Any opposed? All right, thank you everyone this morning. That was very efficient with respect to